My name is Mlondo Mastula. I'm an assistant registrar in charge of small claims procedure, and I sit at the commercial division of the High Court. Small claims procedure is an initiative that was introduced in 2012 to enhance access to justice for the small and medium businesses. It was first piloted in 6 courts of Arua, Mbale, Masaka, Mengo, Gulu, and later rolled out to all magistrate courts across the country. Maybe the viewers may ask, what is a small claim? A small claim is a commercial dispute or commercial debt of not more than 10 million. And we have cases that can be brought under small claims. We have cases like rental disputes, if someone is demanding for areas. We have simple contracts, maybe for produce or goods. We have friendly loans, okay, where one lends another. You're not a money lender, but you lend a friend. In case of a dispute, you can come to small claims. But again, there are those cases that do not fall under small claims. Cases like if you have a case, a dispute against or a debt against the government, you cannot come to small claims. We have contracts for service and contracts of service. Okay, maybe you contracted someone to paint your house and the person did not do the work that you wanted. You cannot come to small claims, however small the money can be. There are also cases arising out of succession. Such disputes cannot be brought under small claims. Divorce, and also land matters. However, for land matters, maybe if there is a sale of land and the other party does not pay the full contract price and the balance is less than 10 million, then the claimant can come to court. There are some unique features about small claims as a procedure. It is very simplified and summarized, where all the forms that one needs in instituting a case are found at court. Forms like what? Demand notices, we have the summons, we have the affidavits, we have the judgments. All those forms are summarized and found at court. For one to institute a small claim, what do you need to do? You come to court and you extract what we call a demand notice. It is the first document that you extract from court. That document is very summarized and it only informs the other person that you're demanding this much money, and if you do not pay it within 14 days, then a case will be opened against you. It is signed by the claimant but sealed with a court seal. That document can be served by the claimant, him or herself, or by a court process server. The procedures of small claims are very complex and informal. We want the parties to participate at every stage. So when the demand notice is served and the other party responds by paying the money, then the claimant informs court and the case is closed. However, in the event that the other party does not pay, the claimant can come to court and then open up a small claim matter. The file is brought before the magistrate and summons are issued at that stage and was again served to the defendant. In the summons, a date is given when the parties are supposed to appear before the magistrate. On the day of hearing, the defendant, because the form is there, can also fill the defense form. If he has a counterclaim, maybe this one, the claimant is telling court that he's demanding for 5 million, but in actual sense, the defendant has already paid part of the money, then the defendant can file a counterclaim and fill that form. Then the parties are allowed to appear before the magistrate. The procedure is very informal, that there are no lawyers involved. Each party will represent himself. And on the day for hearing, a party who has witnesses can bring the witnesses to court. They are entertained, and in a small claim, judgment can be given there and then. If it is not possible, they are given short adjournments. Small claim matters are heard expeditiously. Why? To reduce backlog. To enable the small business people recover their monies in the shortest time possible. We have success stories in small claims, and I can state that for the financial year 2023-2024, using the small claims procedure, the judiciary managed to unlock over 14 billion Uganda shillings. I call upon Ugandans to embrace this procedure so that they can get quick justice. A small claim lasts only 30 days and can only be backlog if it's 90 days. It has very many advantages, like I have taken you through the steps. Under small claims procedure, parties do not need legal representation. No, these are people who know their cases. These are small cases of 200,000, 500,000. They do not really need lawyers. So lawyers are not allowed in small claims. Somehow that is one way cases are heard expeditiously. Under small claims procedure, parties speak the language they understand. They speak their native language. If you're from Busoga, you'll state your case in Lusoga. That way, the court becomes more friendly than the normal civil procedure court, where the procedures are a little complex and parties need to understand. But in small claims, parties participate in their language, and that way they feel more comfortable. It's a friendly court, hence its name, the People's Court. Small claims is more people-centered. We do not have many complex procedures. It is inquisitorial. It is the judicial officer who keeps probing from the parties to get evidence. It is very summarized and easy to understand. I embrace the parties to come to the small procedure courts if they have small cases, debt cases below 10 million. You're welcome. Thank you so much.